Okay, so federalism, we're going to go through and the first part of what we'll do is basically just talk about what federalism is and how it contrasts to other forms of government. That'll be relatively brief. And then sort of tell the story of federalism. And the story of federalism is basically about how there are some important Supreme Court decisions in the early 19th century, some of which have important immediate effect, some of which take a little bit longer to really sort of fully come into their own, and they become even more important in the 20th century as the basis of congressional or Supreme Court decisions. And then the general, though, thing that happens is in the 19th century, you have dual federalism, the view of the states and the federal government being largely just distinct, separate. There's very little overlap, and the states have a lot of important power. In the 19th century, for different reasons, you have the emergence of cooperative federalism, mainly for one main reason. And in cooperative federalism, the federal government comes to have a lot more influence over the states through funding and things like that, okay? So we're gonna talk about what federalism is, give you an idea of what it is, how it contrasts with other forms of government that involves sharing power between a national government and state level governments, and then kind of talk about how the American federal system has developed over time, end with a few discussions about federalism, whether it's good or bad, strengths or weaknesses, what it means for democracy, kind of general questions. And again, I'll try to go through this somewhat more quickly than I normally would, you know, obviously because we're not going to be getting feedback. Your textbook is good, other materials are good, okay? So what is federalism? A federal system is a system of government where the national government and the state governments share power is the first thing, okay? So you have a national or a federal or a central government, and then you have individual state governments, and they share power in some way. They derive all of their authority directly from the people. Okay, so one level of government does not derive its authority or its legitimacy or its power from the other branch. They both the state and the national government, derive their power directly from the people, and the powers of the government are laid out, specified, organized in a constitution, okay? So this isn't just something that kind of falls into place, it's actually by design, okay? It was first adopted or created by the United States. We talked about this, the states were there. The federal government, the new constitution had to recognize them, had to find a way to share power with them. So they created a federal system that has since been adopted by other countries as well, okay? A federal system is in contrast to a unitary system. In a unitary system, the local or the regional governments derive all their authority from a strong national government. A federal system is also different from a confederate system. In a confederate system, the national government derives authority from the states, okay? In the United States, state governments are unitary with regard to local governments, okay? So that's one example. Here's a chart from your textbook. This is section 3.1 from the OpenStax American Government textbook. Okay, there you see it. The unitary system, the national government has all of the real power. It delegates power to the states. But the national government is really where the power and the authority come from. The states are just acting on the basis of or on the direction of the national government. In a confederate system, at the other end, the states have all of the real power and the real authority, okay? They may delegate some to the national government, but the national government is dependent on the states for all of its real authority and power, okay? Unitary system examples, the United Kingdom, Japan, Sweden, perfectly functional modern democracies, okay? So it's not like a unitary system necessarily means that the government has more power or that it's more authoritarian or anything. It's just a way of organizing the relationship between a national government and state or regional governments. Confederation, it's hard to think of functional examples, okay? United States under the Articles of Confederation, because the national government, having no power except whatever the states give it, has no way to really do anything or to enforce anything it might try to do on the states. So these things don't tend to last very long. So Confederate system, hard to think of examples, but there you have in the middle, federation. The people are the source of authority, okay? And the people delegate or give authority both to the state governments and to the national governments, which then share power, okay? Examples, Canada, India, United States, okay? So there's the federal system, there's a good visual representation of what that means, okay? State powers under the Constitution, they really are focused on the 10th Amendment, okay? If you really want to understand state powers, in the Constitution, it's not the only place. There are some other important places where specific powers are given to the states or denied to the states. But in some ways, the real key, especially for long term, the 10th Amendment, okay, the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. And to some extent, the question here is, okay, how much power does that actually leave to the states? And the understanding of what this means and how much power you actually are talking about giving to the states, that changes to some extent quite a bit over time, especially from the 19th century into the 20th and 21st century. But today, the 10th Amendment, one of the main things that really provides for is what we now call reserve powers or police powers. And those are the powers that are reserved to states to legislate for things like public health, safety, morals. That's why states have different legislations about alcohol, for instance, the conditions under which it can be sold, et cetera, where it can be sold, and so on. Public health, okay, so that's a lot of things. These things are left to the states. This is, you sometimes have those old obsolete laws involving regulations about spitting on the sidewalk or something like that. That was for public health, right? So these reserve powers, morality, public health, things like that, these are one of the forms of the state power that are clearly reserved to the states by the Constitution. But that 10th Amendment over time, what does that actually mean? How much power is that actually reserving for the states? You notice it says that the power is reserved to the states respectively or to the people. It's a little ambiguous there. Of course, the expectation was that the states would better protect the rights of the people. Didn't turn out to be the case, especially for African Americans. We'll see this with civil rights. Obviously, the states were not very good at protecting individual liberties and civil rights and so on for African Americans, but also really with civil liberties generally in the 20th century. With the incorporation doctrine, we'll see the federal government actually was more likely to be protecting the rights of individual citizens rather than the states, okay? But that's the 10th Amendment. Again, how many of those powers are not delegated to the United States? In other words, the national government. How many of those powers are reserved to the states? What does that mean, okay? We'll talk about that a little bit more in a minute. Okay, concurrent powers though, when we're talking about the federal system, the national government, the states, how do they share powers? There are things called concurrent powers, okay? Some powers are specifically reserved for the national government. Some powers are specifically reserved for the states. And then there are concurrent powers, powers that are shared by both, okay? So the power to tax, the power to establish courts, the power to make and enforce laws that are necessary to carry out these powers, okay? So concurrent powers are shared by both the federal and the state governments. Some powers, the ability to pass certain types of laws, are denied to both state and federal governments under the Constitution. Okay, these mostly involve commerce and especially civil liberties, okay? Again, from your textbook, a list of the enumerated powers for the federal government, a list of the concurrent powers, and then the reserved powers for the states, and then more powers are denied to the states, a lot of them involving commerce, a lot of them involving international relations, right? Remember, under the Articles of Confederation, the states could form treaties, they could do all kinds of things with other countries, they could do all kinds of things with commerce. A lot of those powers very clearly denied them in the Constitution and instead given to the federal government, okay? But when we're talking about the enumerated powers, we'll get back to this in a second, okay? But there's a chart kind of listing some of the specific powers for each part of government, okay? Relations among the states, remember one of the things that the Federalists were concerned about was the relations between the states. How would they be regulated? And there really wasn't any way under the Articles of Confederation, because again, there was no national government that was strong enough to really regulate anything between the states. It just didn't have the power. Not only could it not act effectively, it didn't have any power at all over the states. So one of the important developments of the federal Constitution was, let's have a way to resolve conflict between the states, and also maybe set up more of a framework for how the states will interact with each other, what their obligations to each other will be, and so on, okay? So relations among the states under the Constitution, disputes between states are resolved by the Supreme Court, okay? So you now have a mechanism to adjudicate these disputes between the states, which again worried the Federalists under the Articles of Confederation, because there was no clear way to adjudicate them. They were worried about tensions and maybe even armed conflict developing among the states. The full faith and credit clause, this basically means that the public acts and records judicial proceedings, contracts, including debt, all of that that you do in one state has to be recognized, has to be given full faith and credit by the other states. So if you get married in Oklahoma and you move to Illinois, you don't have to get married again in Illinois. Your Oklahoma marriage, that document, that public act is recognized. It needs to be recognized by the other states. Same if you enter a contract in Oklahoma. You can't move or incur debt. You can't just move to another state and then it's somehow not valid there. This was somewhat significant in terms of policy and so on a few years ago before gay marriage was recognized by the Supreme Court, and there was some differences between states and whether or not they recognize gay marriage, and that could have some practical consequences. This is important, full faith and credit clause, it's there, but it's not, the source, or it's not part of very many really pressing debates at this point. Okay, the Privileges and Immunities Clause, this basically says that states have to treat the citizens of other states, has to grant, each individual state has to grant the citizens of other states all the privileges and immunities that they would grant their own citizens. And then so you can't discriminate, or a state can't refuse to help or to do certain things for somebody because they're the citizen of another state. And then there's the extradition clause. The Privileges and Immunities Clause, obviously, if someone is a resident in another state and they're not registered to vote in your state, they can't vote there. It's not like you have to do everything, but you do have to give some of the same privileges and immunities in terms of legal protections and things like that. Then the extradition clause, right? If you're wanted for a crime in one state and you live or you flee to another state and you get arrested there, they're obliged to extradite you, okay? So those are some of the relations among the states. They're not, they're important. They are not usually pressing matters of policy and debate and so on right now, okay? So we're talking about what federalism is, what the Constitution does in terms of some state powers and relations among the states and so on. Let's look at national powers under the Constitution, okay? The national powers, the powers that the Constitution gives the national or the federal government, the first set are the enumerated powers, okay? These are the powers that are explicitly listed or enumerated, listed, numbered out and listed in the Constitution. The power to tax, the power to coin money, the power to regulate commerce, the power to provide for national defense. These are, in some cases, coining money, that's pretty specific, but something like providing for national defense or regulating commerce, these are very broad powers. A lot of things could be involved in regulating commerce or providing for the national defense, okay? But these are the enumerated powers. These are the ones that are listed by name, basically. Then there is the necessary and proper clause. And we remember Brutus's concerns about that. Remember, Brutus was very concerned that the necessary and proper clause, which says that Congress has the power to pass any laws it deems necessary and proper to carry out the enumerated powers. Brutus was very worried that that necessary and proper clause would be used to expand federal power in all kinds of ways. And he was largely right. Brutus, some of the other anti-federalists, worried that the necessary and proper clause meant that Congress could do things that violated other parts of the Constitution. And that's clearly not the case. Okay, so Congress, the federal government, is limited by other things in the Constitution. So the necessary and proper clause doesn't mean that they can do something that is clearly unconstitutional. But in other ways, they can expand federal power. They can do all kinds of things that may not be specifically listed if it can be justified, if they can say, well, we deemed it necessary and proper to carry out one of those enumerated powers, okay? So the necessary and proper clause gives Congress a lot of leeway, a lot of authority. There are many, many things. In fact, the necessary and proper clause comes to be known as the elastic clause, a kind of sarcastic term for it. You know, it can be stretched to justify or to encompass almost any kind of new legislation. Can be justified under the necessary and proper clause, okay? So when you take the enumerated powers and the necessary and proper clause, you get the implied powers. And the implied powers, this is based on a Supreme Court ruling, McCulloch v. Maryland, okay? The implied powers are basically powers that are implied but not specifically mentioned. Again, they're derived from a mixture of the enumerated powers and the necessary and proper clause. So the notion is, if you think that Congress, and therefore the national government, is doing something that the Constitution does not give it power to do, because the Constitution doesn't specifically say it can, for instance, create a national bank, charter a national bank, it's implied that they can, okay? The implied powers, it's not that, that's a specific thing that's listed, founding a national bank or something. It is implied by the notion that they can regulate commerce, and then they can pass any laws that they deem necessary and proper to do that, provided that founding a national bank is not obviously unconstitutional, then it is an implied power, okay? So implied power is an important part of understanding how the federal government operates and how it exists and the powers that it actually has under the Constitution. And again, this is pretty much by design, right? The anti-federalists, people like Brutus, recognize that this is what the Constitution would do. So it's not like this is some sort of strange abuse of power. It is largely by design that Congress can pass new laws. And again, the idea is when they wrote the Constitution, they couldn't possibly foresee all the different things that might need to be done in the future. So they gave Congress, and again, Congress here is sort of, Congress will pass the laws and thereby create powers and institutions and legal requirements and everything else for the entire national government, okay? So Congress is specifically mentioned, and it has to go through Congress. The necessary and proper clause doesn't apply to the president. But when you talk about Congress here, you're talking about the federal government generally. So Congress has the power to do these things, and the notion was the founders couldn't possibly foresee every single thing that Congress might need to do in the future, so they gave them a few very broad powers. Again, some coining money, that's pretty specific, and then obviously, but again, they don't necessarily say you can set up X number of national mints or buildings for the national mint or printing presses to print paper money eventually. All of that is left for Congress to figure out in due time, and therefore the idea is there are a lot of powers that are implied. And with more general things, regulating commerce, providing for national defense, these are even more obvious. That they can't possibly foresee everything that's going to happen in the future. So give them some very broad powers and then Congress can pass the laws that it deems necessary and proper to do these things in the future. We can't possibly think of all of them. If we tried to list them all, the Constitution would be thousands and thousands of pages. And again, we still would not be able to foresee everything that needed to happen. So by design, Congress has a lot of leeway, has a lot of things are going to be justified under the doctrine of implied powers. A lot of things are going to be implied powers, not because it was even implied intentionally, like they meant to say that it was implied. They assumed that everybody knew that Congress could create a national bank. There's a whole broad range of things that Congress can do as it's an implied power. Okay. So federalism in the Marshall Court, okay, McCulloch v. Maryland, that was about the national bank. That really kind of enunciates or really kind of puts on the record as a Supreme Court decision the doctrine of implied powers, that is constitutional. Seems clear enough, especially in retrospect, but it actually said this is constitutional, it's now official, and the doctrine of national supremacy, okay? National supremacy says that when a national law conflicts with a state law, provided that the national law is constitutional, the national law is supreme. It trumps the state law. It invalidates the state law if need be. So in this case of McCulloch v. Maryland, there was a conflict between the creation of a national bank and certain state laws. And the Marshall Court, the Supreme Court, John Marshall was the Chief Justice, said national laws are supreme over state laws. Again, provided that those national laws are constitutional, they are supreme over state laws. They trump them, they supersede them, okay? So important decision. It says Congress has the implied powers. Okay, it makes that actually part of the understanding of the Constitution. Okay, and it also says national laws are supreme over state laws. Again, this is pretty clear in the Constitution. It's not surprising that they came to that decision, but now it's official. Now it's stated there in a Supreme Court decision, and it's clear. Okay. Marshall's basic idea here, the basic argument of the court, the federal government is limited in power, okay? It's limited in power by the Constitution, but it's supreme within its sphere of action, okay? So that's, again, national supremacy, okay? So federalism in the Marshall Court, the implied powers, the necessary and proper clause are used again and again after McCulloch v. Maryland to justify expansion of the powers and actions of the federal government. But again, that's pretty much by design. It seems pretty clear that that was the intent, that is going to happen and that they can foresee that. And that's the point. We don't know what will need to be done in the future. But things will need to be done, and those will effectively be expansions of power and actions by the federal government. New departments will be created, new laws will be passed, new taxes will be levied, etc. Okay, another important early decision in during the Marshall Court, Gibbons v. Ogden, and this becomes even more important really down the line. But this gives a broad interpretation of the Commerce Clause and says that Congress has the power to regulate commerce in all kinds of areas between, if anytime you're talking about commerce beyond one state. And so it's a specific thing that was relatively minor. We don't really worry about the specific case involved, kind of like the National Bank in the 1810s, but the interpretation of the Commerce Clause becomes very important later on, okay? So Gibbons v. Ogden, an important decision, and the basic idea is Commerce Clause interpreted in a very broad way, so Congress has the power to do all sorts of things, provided that it can be justified under the necessary and proper clause as regulating commerce, okay? So that was the Marshall Court. Go on a little bit, the horrible Justice Taney and his court. Basically, during the Taney Court, you have the real development of dual federalism, okay? Which was effectively what was happening under the Marshall Court as well. I mean, there were some important decisions, some of which, again, probably stated things that were relatively clear, but, it's good that they were stated and made clear and official by the court. But there was still a lot of power for the states, even during the Marshall Court. Dual federalism is really articulated in really kind of the legal doctrine under the Taney Court, and also well after that, actually. But dual federalism, the basic idea is that you have the different levels of government, the federal government, the state governments, they are separate and equally powerful. There's almost no overlap in terms of what they're actually doing. So, for instance, in the Dred Scott decision, usually well known for other reasons, but one of the things that the court ruled in the Dred Scott decision was Congress cannot try to regulate slavery in the territories, only the states can. So it said slavery is a state issue. Congress has no business trying to regulate slavery whatsoever. You can see all kinds of reasons why you might justify that: commerce, national defense, but the Taney Court said, no, that's actually a state issue. So state power and state autonomy was kind of at its high point with dual federalism, okay? Now, after the Civil War, there are obviously 3 new Civil War amendments, okay? The 13th Amendment abolishes slavery. So that obviously changes things, and that makes the national constitution very important, because it says now slavery, this dominant political and policy issue for the past at least 20 years before the Civil War, now it's over. And it's been decided by the U.S. Constitution. Okay, so now there's no question of whether the states can regulate slavery or what that means. It's gone now. Okay, and that's because of the federal Constitution. Okay, the 14th Amendment then says all citizens have citizenship rights as citizens of the United States. They are all citizens of the national government, and no state can interfere with the rights that they have as citizens of the national government. Again, what that means for civil liberties and for civil rights, it takes a while. Those things don't really get articulated and become a really kind of live political reality until the 20th century. But the 14th Amendment really changes in important ways the relationship between the national government and the states by saying very clearly, everyone is a citizen of the national government, and the states cannot interfere with some of those rights and protections that they have as citizens of the national government. And then the 15th Amendment grants everyone, which at the time really just meant all men, the right to vote. And again, that takes some power away from the states and says the national government, the Constitution specifically, is now saying all men can vote. That wasn't the reality. It wasn't the reality for, basically almost 100 years. But again, the Constitution, the law, what does it actually say? What is the balance of power between the national government and the states? Those Civil War amendments clearly give a lot of important powers to the national government. And the 14th Amendment, maybe most of all, though again, it takes a while for people to really read that and decide, really realize what it says, okay? So the court continues to uphold dual federalism. For instance, in Plessy v. Ferguson, a case where the court said segregation is constitutional. It's the very end of the 19th century, so it's decades after the end of the Civil War. It's a good 30 years after the Civil War ended, and it said states can segregate. The idea was the 14th Amendment says equal protection of the laws. Plessy v. Ferguson said, as long as the facilities are separate but equal, in the famous phrase. So the idea was it doesn't violate the 14th Amendment and the Equal Protection Clause of the 14th Amendment, provided that when you're segregating, you're providing equal facilities, okay? Now, in practice, the facilities were never equal. The entire point was to create a system of inequality and of hierarchy, which is exactly what the Supreme Court says later in Brown v. Board of Education, okay? So constitutionally, things have changed, and things like segregation have to be justified in somewhat different terms now, okay? But in practice, you still have something like dual federalism. You still have a lot of independence for the states. Okay, and we'll talk about all of this segregation, these different Supreme Court decisions, the 14th Amendment, all of that when we talk about civil rights in particular. But you still effectively in practice have something more like dual federalism, where again, the states have a lot of autonomy, okay? This starts to change, and again, these things don't necessarily change immediately, but the groundwork for some really important changes start to happen during this sort of progressive era. Two important amendments ratified in 1913, okay? The 16th Amendment gives the national government the power to collect income tax, okay? And relatively quickly, I mean, not necessarily in 1913, but over the next couple decades, that means that the national government becomes relatively wealthy, certainly compared to the states. So as the national government begins to collect income taxes, and for other reasons, they come to have much more wealth, and therefore when they start to partner with the states under cooperative federalism, their greater wealth gives them influence. It doesn't change the Constitution, it doesn't give them more legal power, but it gives them much more influence over the states, and we'll talk about that in a minute. Okay, then the 17th Amendment, also ratified in 1913, the senators are elected directly by the people now, not by state legislatures. There were different reasons for that. One of it was that legislatures were sometimes deadlocked. That's what that cartoon is about. But the states, in a way, lost a lot of their influence in Congress, as senators no longer thought of themselves as representing states as institutions or as government entities, but thought of themselves as representing the people of the members of those states. So Congress became much more, the Senate in particular, became much more comfortable with exercising federal power. And this has important things, this has important consequences for civil rights, as arguments about states' rights matter less than the fact that the vast majority of northern and southern states dislike and think segregation is wrong. But it also matters because the senators now can see themselves as just exercising congressional power, federal power. And again, they don't necessarily think of themselves as representing the states as entities or as governments, okay? So again, this is, and there were very good reasons for the 17th Amendment. Part of it was just the people should be electing the senators. Part of it was problems with corruption and deadlock and so on in the state legislatures. But this also has an important long-term consequence for federalism. Okay, the real turning point is cooperative federalism. Okay, this is the New Deal, right? You have the Great Depression, and the federal government creates all of these programs to help to deal with that, okay? And the federal government, even though it's the Great Depression, the federal government at this point still has far more money. So you start to see what's going on during the Great Depression, and some of these programs end with the Great Depression, but this basic system of partnership, of overlap, of partnering between the national government and the state governments, and the national government having far more money and therefore far more power or influence over the states, not legal, not constitutional power, that doesn't change, but the federal government basically says, let's partner in an area like highway construction or education. And we have all this money that we will give you and help you carry out, these state issues of, providing transport, building highways, providing education. However, you're going to have to do certain things if you want that to happen, okay? So they don't require it. It doesn't change the legal or the constitutional reality that states can do a lot of things, but it does make the states effectively dependent on the national government because they come to become dependent on this money that's coming from the national government. Begins during the new year, but continues decades and continues today, really. And we'll talk about how it changes, if it does change, in a few minutes here. But the image, I hope whoever came up with this copyrighted it or something. The image that is always used, dual federalism, is like a layer cake, two separate layers. You cut into it anywhere, you can see which layer is which, right? If you look at any policy under dual federalism, you can see whether it's a federal policy or a state policy. You can always see what the federal government is doing and what the state is doing, and they're very clearly separated. Under cooperative federalism, on the other hand, it's more like a marble cake. If you cut in anywhere, you're going to get a mixture of them. It's much harder to say, this is what the federal government is doing and this is what the states are doing. This is a federal power, this is a distinctly state power or a distinctly state area of policy, because they're cooperating all over. And almost anywhere that you look, you see cooperation and overlap and mixing between the two levels of government, okay? So again, begins during the New Deal. It continues these partnerships in all kinds of policy areas, including highways, but education, health, all kinds of areas. Okay, the federal government has more money, and therefore they have more power because, again, in these partnerships, the states are much more reliant on the federal government. So federal grants to states are expanded greatly during Lyndon Johnson's administration, and they're often used to effectively compel the states to act as the federal government wants. Sometimes that's good, right? Desegregation. So Brown v. Board of Education in 1956 said segregation was unconstitutional. President Eisenhower federalizes the National Guard, tries to use the executive branch to enforce that, to begin to push for desegregation, but it happens very slowly, if at all, until finally Congress says, okay, any state government that is found to be practicing segregation that has not integrated will not receive federal money. And that was kind of the thing where the states, the southern states, the states that practiced legal segregation couldn't take that. They weren't willing to turn down the federal money in return for continuing to segregate. So in that case, the federal government was able to encourage, because again, they didn't legally force them, and they certainly didn't physically force them. Legally, it had already been decided in 1956. The fact that almost 10 years later, Congress has to say, okay, we're going to make federal funding contingent on desegregation or integration, that's legally it had already been decided, right? Segregation is unconstitutional. It's the fact that access to this federal money is conditional on states desegregating. That's what ends up making it a reality, okay? The drinking age. Obviously there's a national drinking age of 21. I was saying earlier, all kinds of alcohol regulations are state issues. That's part of the reserve powers. States can decide how old they want their citizens to be before they can drink. And yet there's a national drinking age of 21. That's because there was a national law passed saying that federal money for highways will be contingent on the state having a drinking age of 21. Okay, so all the states basically voluntarily changed their drinking age to 21 to have access to this money for for highways and so on. Okay, so the federal government didn't pass an unconstitutional law saying we now have a drinking age of 21. They didn't pass that law and challenge it and have it held up in the courts as constitutional. They just said any state that has a drinking age lower than 21 will no longer receive federal funds as part of this particular program. And all the states voluntarily changed it to get that federal money, okay? So cooperative federalism, partnership between the national government and the states, national government has more money, and therefore the states become sort of dependent on it. And so the national government comes to have tremendous influence over state policy in many areas, okay? With Ronald Reagan, you get something called new federalism, okay, which is, you shouldn't overstate how much of a change that it was. It was sort of a movement towards giving the states more power. So it was more, we're going to continue to give states these block grants. So we're not going to stop, we're not going to pull back the federal funding from the states. We're just going to give them a lot more discretion. We're going to put fewer conditions or fewer requirements on that aid. Kind of Nixon pioneered it, Reagan did it, the Republicans in Congress in the 1990s did it, kind of an attempt to give more power back to the states. That National Drinking Age Act actually was passed under Ronald Reagan though. So it wasn't an absolute thing. I mean, he signed the bill saying that, we need to have states will only receive highway money if they have a drinking age of 21. In any case, this new federalism was largely reversed by the Bush administration. For instance, the No Child Left Behind education policy made federal funding for state education programs contingent on them accepting this particular test and using that to measure student progress and outcomes and all that, okay? So there was a very clear attempt to take the federal government and the federal funding and to say the states will only have access to this if they do what we at the federal level want, okay? Also, medical marijuana, states were trying that and the Bush administration shut it down. State emission standards, the state of California basically wanted to have higher emission standards than the rest of the country. The Bush administration sued them to stop it, okay? California, part of it might be ideological or a policy thing that they just want cleaner air or they want to do more for the environment. But a lot of it, of course, is they're very densely populated. They have cities, I mean, California, Los Angeles, the smog, the mixture of smoke and fog is kind of legendary. So they had very real reasons why they might need higher emission standards. And that's kind of one of the classic justifications for federalism, right? California might need different emission standards than Wyoming or Alabama. So let California devise theirs and let Wyoming devise theirs and let Alabama devise theirs. And they can all adapt their emission standards to what is good for their state. The Bush administration, though, didn't like what California was doing, so they tried to stop them, and they did. Okay, so the Bush administration, new federalism goes out the window. The Bush administration is much more comfortable using the federal government in different ways to thwart state initiatives if they don't agree with them, right? They're willing to use the federal funding to enforce No Child Left Behind, to get all the states to adopt this particular test and this particular method for assessing student outcomes and student learning. And they're also going to use the federal government to try to stop state experiment with things like marijuana or higher emission standards, okay? The Obama administration tended to favor state power. They let not just medical marijuana, but they let states start to legalize recreational marijuana, which is in clear tension or violation or disagreement with national laws. But the Obama administration and then the Trump administration and so far in a week or two, the Biden administration, but will probably continue, they have not moved against that. The national government hasn't repealed those laws, so it's still kind of an odd thing, still not total clarity about what the laws are, but the Obama administration let the legalization of marijuana happen and didn't try to interfere with it, even though it violated federal law. Okay, he allowed states to, or the Obama administration allowed states to devise their own emission standards, okay? So actually, with the Obama administration, there was a bit more freedom for the states and there was a bit more allowing the states to experiment and to do their own things. But to some extent now what you have really is more that both parties are fairly comfortable using the federal government to try to create or encourage certain policies. So it's less about a principled attitude towards how much initiative or how much autonomy the state should have. And it's more that if we like the policy, we'll probably let you do it, but we're also going to be comfortable threatening to withhold federal funding to get you to stop a policy that we don't like. So the notion, I mean, it still has some resonance, people still talk about it, but federalism as maybe being a really kind of essential principle that people really have, that to some extent is over, okay? So finally, why is federalism important? In simplest terms, it decentralizes politics. But really, the really essential thing is states often pioneer policy, right? So states can, in terms of nationally, why is it good? Why is it helpful? States sometimes, like women voting, for instance, various states gave women the right to vote before the 19th Amendment was actually passed, okay? And women were given the right to vote nationally. States pioneered policy. States are sometimes then referred to as laboratories for democracy, where people can devise new policies, and sometimes they work so well that they become adopted nationally, okay? So that's a good thing, right? It also, of course, enables people to adapt policy to local needs. Like we were just saying, the city of Los Angeles, and maybe the whole state of California, may need higher emission standards. Air pollution from traffic, a lot of people are driving, different environmental factors mean that the air pollution is going to be trapped there, and worse, they may need very different emission standards than a much more sparsely populated place where the population is much more spread out, okay? So let them adopt, let them craft the laws that best work for their situation. And let other states where they don't need to worry as much about air pollution craft different laws for that, okay? And more diversity of opinion. If you see policy as largely expressing values or ideas that people have, again, people in Montana might have different attitudes than people in California. And in other ways, they may not, right? In other ways, California and Montana may have the same attitudes about certain things that are very different from the attitudes in Mississippi and Alabama. Let them kind of do what they think is best, okay? Disadvantages for democracy, one of the major ones is different states have different amounts of resources. So public education, public health, if you look at those outcomes for public health, for instance, it can make a big difference what state you're going into. So as rather than having, we do have some national policies for some of these things, but oftentimes it's left to the states, and it's not just a matter of ideas or principles or what they want to do. Sometimes it's just a matter of how much money they have. So when you come to things like public education, public health, those can look very different depending on what state you're in because of how much money the state has to actually provide for it. Now, some of it could also be state ideas, you know, how much do they want to invest and what other things do they want to do to make education better or to make health better, to make public health better. But, you know, different states have different resources, so that can be an issue. It can actually discourage public services. California used to have a much more extensive welfare program, and people would actually move there from other states to collect welfare. If there were a national, I mean, there are some national programs, but if there were a simple national welfare program and everybody got the same thing, it wouldn't be up to the states, and you wouldn't have issues like that. You can have what people sometimes refer to as a race to the bottom. Again, as you're trying to attract new businesses, you can give tax cuts, you can make weaker labor laws, weaker environmental laws, and states can kind of be competing to get Amazon or whoever to come in by creating the most advantageous environment for that business, and that can be bad, right? That can end up with bad things for the state as a whole, for the area as a whole. Harder, at least in theory, for some of these companies to have that kind of influence at the national level. At the state level, one major company might have a lot of influence, and they might be able to pollute much more or to have very bad labor practices and get away with it at the state level because they have so much influence. At least if you go back a few decades, it was harder for some of these things to have that kind of influence at the federal level. To some extent, certain companies have become much more powerful, and maybe they have more influence at the national level now as well. The other thing is local interests, local attitudes, okay, they are not always good, right? Civil rights, segregation, that was federalism. Let this state segregate, let that state not segregate, that's not really very good, okay? So local interests are not always good. Again, the federal government in many cases has done a better job, despite what the anti-federalists expected. The federal government in many cases has done a better job of protecting individual rights than some of the states. Whether that's for African Americans generally or for individuals who, for different reasons, the individual states may not have as many civil liberty protections as the federal government does. Okay, so local interests, local attitudes, local policy, not always that good. The ideal is it's adapted to conditions, it's what's best for the people in that area, but it doesn't always turn out that way. Okay, complexity of government, federalism does make government more complex. Sometimes you'll have trouble, understanding, is this a state thing, is this a federal thing? The anti-federalists concerned that the more complex and difficult to understand government was, the more people would disengage and just sort of stop being citizens, stop worrying about it, okay? Federalism can contribute to that, okay? So bottom line, final question, okay? Does federalism leave too many essential rights and duties, okay? Public education, public health, things like that, to be, as well as, social safety nets of all kind, environmental laws, labor laws, all kinds of things, right? Does it leave too much to be determined according to the resources or just the inclinations of the individual states, or is the flexibility and the ability for states to adapt laws to what really is essential for them and what really works for them, is that worth the payoff? And there's obviously no simple objective answer there, okay? But you've seen some of the advantages, some of the disadvantages, and you can certainly think about that and continue to think about what the correct answer might be. Or, again, there's not gonna be one correct answer, but you can think about what is at stake and maybe recognize some areas where federalism works and some areas where it does not work.